The Belgian state appoints a bailiff. The eviction is set in motion, not because everything has been clarified, but as if it had long since been decided. And all this while proceedings are still pending. An opposition proceeding concerning a company in liquidation that was never involved in the eviction proceedings, a summary proceeding that is still pending, and a disabled child who also lives in that house. But the state continues, without pause, without doubt. In the eviction proceedings, it is presented as something that is settled, a confiscation, a forfeiture, a property that supposedly already definitively belongs to the state. And that is precisely where the danger begins, when one party presents its version of events as an established fact, and no one verifies the underlying foundation. That version becomes the truth. What still astonishes me is this. No one asked for the original criminal judgment. No one asked for proof of service. No one pulled the emergency brake and said, "Wait, let us first verify what the judgment actually says and whether it has been communicated correctly." Everything was accepted on the basis of what the state declared. And that is how a self-perpetuating system is created. If a judgment has not been served, if the core facts of what that judgment actually says are never examined, if the crucial documents are not there, then an eviction order becomes almost inevitable. Not because it is correct, but because the file creates that impression. And then there is my child, disabled. At first, an attorney was appointed. Within days, that attorney withdrew, after first stating that the case could be handled without difficulty. No solution, no time, no real defense. The Bar Association did not appoint a replacement. And suddenly, you are standing there alone, as a mother, against a state that has been set in motion and no longer stops. The eviction of a family with a disabled child and the role of the court bailiff. 1 week before the eviction was to take place on March 6, 2024, and the bailiff even called several times. On February 15, 2024, the court bailiff acting on behalf of the Belgian state called regarding the planned eviction.
Het is op 6 maart, maar ja, gaat u nog actie ondernemen of niet? Want u moet dat ook begrijpen, dat is voor mij een hele organisatie.
Maar u hoort nog van mij, nog voor die datum.
Ja. Oké, dan zet ik alles in zijn werk, dus dan moet ik iedereen organiseren. Dat kost ook een hoop geld, maar ik zal dat dan doen.
The bailiff was aware of the summary proceedings that had been initiated, which were scheduled for the same day as the eviction. Yet he did not deviate from the planned date. It seemed as if he already knew the possible outcome of the summary proceedings.
Ja, nou ja goed, het valt natuurlijk gelijktijdig. Dus ja, kan niet op 2 plekken tegelijk zijn. Dus dan moet ik de boel openbreken. Ik moet toch in Brussel zijn. Dus ja, dat gaat niet anders, hè?
Ja, bekijk het maar, hè. Maar ziet dat ik dat dan krijg, dan kan ik u antwoorden, hè, of dat wij dan doorgaan. Normaal gezien gaan we er gewoon mee door, hoe zeg je?
The bailiff remained committed to carrying out the eviction and simply proceeded despite objections and ongoing legal proceedings.
Niet tegenstaan, dat gaat het gewoon door. Hè? We gaan gewoon dat...
Maar als ik om 9 uur in Brussel moet zijn, kan ik niet om 9 uur in Turnhout zijn.
Nee, maar dat maakt ook niet uit of dat weer bent of niet, hè?
Maar dan zit ik hier met al mijn spullen en computers en zo.
Wij zijn gerechtsbewaarders en wij doen al heel ons leven lang doen wij uit huiszettingen. In 9 van de 10 gevallen zijn de mensen niet thuis en wij doen gewoon ons werk.
Krijgt morgen, of tenminste morgen, krijgt de FOD ook nog een derde verzet. Daar was een fout in gemaakt, want het is gewoon als een nieuwe zaak neergezet. En u kunt gewoon niet uitzetten de persoon die niet in deze hele uitzettingsprocedure betrokken is geweest. Die een contract heeft.
Ja, maar het zin dat u naar de procedure zijn, volgens mij die schorsen allemaal niet, hè? Dus wij mogen gewoon doorgaan, besef dat.
The bailiff knew that he was evicting a family with a disabled child, while proceedings were still pending, including summary proceedings in Brussels. Yet he carried on as though none of it counted. That was not merely a lack of care, it was a display of power directed at vulnerable citizens. And that is exactly what happened. On 6 March 2024, at 9:00 a.m., summary proceedings were being heard in Brussels. I stood before the judge and explained that I was about to be put out on the street with a disabled child. At that very moment, my home was being cleared out by the bailiff with police assistance. I was forced to make an impossible choice: stay before the judge or be present at my home while my belongings were removed. That wasn't really a choice at all. The concerns were raised, they were heard, but they changed nothing. During an earlier conversation, I asked the bailiff what would happen to my belongings if the eviction went ahead. This was his answer.
Mee met naar het stort. En hetgeen dat nog wel bruikbaar is, maar dat niet eigenlijk in beslag neembaar is, of dat niet de moeite is om in beslag te nemen, dat gaat mee naar de gemeendemagazijnen, waar dat u dat nog gedurende 6 maanden kan ophalen.
But no inventory was ever drawn up, and the belongings left behind were not addressed, while photos and videos show that the house was not empty. Where did these belongings go? Even though an emergency situation had arisen and summary proceedings had been filed on grounds of urgency, the judge took the matter under advisement, and we would hear the outcome later. But it did not count. It was dismissed and rejected. The eviction had already taken place anyway. As if the treaties and protections promised by a state governed by the rule of law, especially for a child with a disability, suddenly no longer applied. After the hearing in Brussels, we drove to Turnhout. The house was still being cleared, according to the bailiff's official report. On my instructions, the workers engaged by me proceeded with the removal and placement of the furniture and other movable property. Those workers were police officers, as confirmed in the official report. All belongings were stored on pallets, packed up, and disappeared, not placed on the street but locked away, later collected and gone, the training equipment for the disabled daughter. Yet the official report contains no record of those belongings.